Hey everybody, hope you all are doing fine in this pandemic and everybody is safe. My name is Kiran Choubey and today I'm going to discuss the topic Sexual Harassment of Women at Workplace Act 2013. This is the very important act which is passed by the legislature for the safety of women. So let's start the topic. Here is the brief introduction about myself. My name is Kiran Choubey. I'm pursuing BCom LLB from Banasthali, Vidyapeeth, Rajasthan, and I'm the member of All India Human Rights Association. What is the agenda for this particular topic? First, we will discuss what is the historical context of sexual harassment, background of Sexual Harassment Act, brief of Sexual Harassment of Women at Workplace Act 2013, one landmark case law which is Vishakha and others versus State of Rajasthan, objectives of the act, sexual harassment, duty of the employer. Let's discuss the first point, historical context of sexual harassment in India. India being a very patriarchal society and faces the distinction of very deep rooted history of sexual harassment in the society. So, what is the meaning of patriarchal society? Patriarchal society means our Indian society is the male dominated society. Here, females are not being empowered, but this was the case in older times. Now, the society has changed. In old times, women were not allowed to get education or to work independently. We are well aware of this point. In that time, there were no laws to protect women, but there were cases of sexual harassment. Background of Sexual Harassment Act 2013. As we know that there was no concept of education or work in older times, but gradually the society opened and started giving attention to educating girl child. Then the women in India became empowered through education and started gaining the seat in workplace and the cases of sexual harassment got increased. Then there was a need for such kind of law which could curb these acts in the society. The Prevention of Women from Sexual Harassment Act of 2013 was passed by the legislature to eradicate harassment of women at workplace. So before studying about any act or any law, we should first know the background that why this particular act or why this particular law came. If we could not just determine the background of the particular act, we would not be able to analyze the importance of this act. What was the need for such kind of act? In this particular slide, I'll discuss the brief of Sexual Harassment of Women at Workplace Act 2013. What was the act all about? The act was passed to protect women from sexual harassment at their working place. So, as the name suggests, that the women were feeling unsafe at their workplaces, they were being harassed by the third party. So, the act was passed to ensure that the women are safe at their working places. So, that's why the name suggests that Sexual Harassment of Women at Workplace Act 2013, Prevention, Prohibition, and Redressal. The bill was passed by the Lok Sabha on 3rd September and on 26th February 2013 by the Rajya Sabha and got assent of the President on 23rd April 2013, but this act came into force from 9th December 2013. Now this is very important. These dates are very important, that when did the bill passed in the Lok Sabha, then Rajya Sabha, and then finally got the assent of the President on 23rd April. But when it came into force on 9th December 2013, this date is very important, that when did the Sexual Harassment of Women at Workplace Act 2013 came into force, when this particular act came into force. So it came into force from 9th December 2013. The Act ensures that women are protected at their workplace, be it public or private. So, this Act ensures that the women are safe and protected at their workplaces, not only in the public places but also in the private places as well. By passing of this act, it provides security to women and the participation of women in work improves, which results in economic empowerment. Now, what happens that sometimes the family also do not allow their daughters to move out of their homes. The reason is obvious because of the rise in cases with the women. So they don't feel safe, and the women were not allowed to move out. So, after passing of this act, the participation of women in work also improves. So, if they are earning independently, then there is economic empowerment. So, the women are actively working everywhere in every sector, be it sports, education, everywhere. This is the very leading case law on sexual harassment, Vishakha and others versus State of Rajasthan. The citation is also mentioned AIR, that is All India Reporter, 1997, SC 3011. Prior to the passing of this law, the matters related to sexual harassment was directed by the guidelines laid down by the Supreme Court in Vishakha versus State of Rajasthan. So, when this particular act was not passed in India, the matters pertaining to sexual harassment were dealt by the guidelines mentioned in this case. The guidelines were passed in this case, and it became mandatory for the employers to provide mechanisms in order to prevent these kind of acts and to provide effective resolution of cases related to sexual harassment. So, not only the guidelines were issued by the Supreme Court, but uh, it was to be followed mandatory by the employers, so that if any case of sexual harassment is there, the case should be resolved effectively. The guidelines also mentioned the definition of sexual harassment. We are just only saying sexual harassment, sexual harassment. What is sexual harassment? So, under these guidelines, there was a term mentioned, sexual harassment, the full fledged definition of sexual harassment. The Supreme Court also mentioned that the guidelines provided should be strictly followed in all places, rather I should say in all workplaces, for the preservation and enforcement of the right to gender equality of the working women. The guidelines which were issued by the court was treated as a law declared by the Supreme Court under Article 141 of the Constitution of India. First, what is Article 141? Article 141 says that the law which is passed by the Supreme Court, it is binding on all the subordinate courts. Okay, so the guidelines which were issued by the court, those guidelines were not at all like a bill or an act, but it was treated as a law declared by the Supreme Court under Article 141 of the Constitution. And when the Act of 2013 was not passed, then every case of sexual harassment were dealt by these guidelines only. So it was treated like a law. But it was observed by the courts that the guidelines were not strictly followed, and there is a need for detailed legislation on sexual harassment at workplace, its prevention and redressal mechanism. The Supreme Court passed the guidelines or issued the guidelines, but the subordinate courts felt that these guidelines were not at all strictly followed. So, we need a detailed legislation on sexual harassment at working places, its prevention, how we are going to prevent those acts, and the redressal mechanism, that if the sexual harassment cases comes in the organization, then how we are going to resolve those cases. So almost after 16 years of Vishakha guidelines, Government of India passed a comprehensive law on sexual harassment of women at workplace, prevention, prohibition and redressal act of 2013. So Vishakha case came in the year 1997. So almost 16 years this act came into force, the act of 2013. Let's discuss what is the objective for this particular act, why this particular act was passed. The main objective for the passing of this act is to provide protection against sexual harassment of women at workplace and for prevention and redressal of complaint. Another objective for passing of this act is that sexual harassment results in violation of the women's fundamental rights, which is guaranteed by the Indian Constitution. As we know that there are fundamental rights which is guaranteed to each and every citizen of the country. So if there is a case of sexual harassment, then those fundamental rights are being infringed. That is Article 14, Article 15, Article 21, Article 19, Clause 1, Subclause G. Article 14 says right to equality, means everybody is equal in the eyes of law. Article 15, discrimination on grounds of gender, race, caste, sex, and place of birth. Article 21 says right to life and to live with dignity. Article 21 is the very, very important fundamental right, because this fundamental right is not at all taken even during emergencies. Article 19, Clause 1, Subclause G says right to practice any profession or to carry on any occupation, trade, or business to all citizens, which includes right to safe environment free from sexual harassment. So, Article 19, Clause 1, Subclause G is also very important. Anybody can do any business, any trade, anywhere. There is no bar in that, but uh, where the business is done, the environment should be safe and free from sexual harassment. So these are some fundamental rights which are being violated if there is a case of sexual harassment in the organization. Here I'm going to discuss the term sexual harassment. From the very first slide, we are discussing sexual harassment at workplaces, Act 2013, Vishakha guidelines. So, what is sexual harassment? The Act defines the term sexual harassment on the line as it was defined by the Supreme Court in Vishakha guidelines. In Vishakha guidelines, also, as I mentioned earlier, that sexual harassment full-fledged definition is defined. So in the act also sexual harassment is defined. Section 2 clause n of the act defines sexual harassment as follows. Just remember this section. Section 2 clause n. Sexual harassment includes any one or more of the following unwelcome acts or behavior, whether directly or by implication. Namely, the first one is physical contact and advances. Secondly, a demand or request for sexual favors. Thirdly, making sexually colored remarks. Fourth, showing pornography. Fifth, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. So there are some 5 points, but these are not exhaustive. But in the act, it is defined that if there is a case of sexual harassment, how we are going to determine that this case falls under sexual harassment. So in the act, it is defined. Duty of the employer. We are talking about since beginning that sexual harassment at workplace. So workplace means where? In the organization, obviously, where the women are working, that is called workplace. So if the case of sexual harassment is found there, then what is the duty of the employer? If the case of sexual harassment is done with the employees, then what is the duty of the employer? What is the primary duty of the employer? It is the duty of the employer to prevent safe working environment for every employees working under the organization. The adequate steps must be taken towards protecting the interest of women employees and ensures that none of the employees indulge in sexual harassment. Appropriate action must be taken if any case regarding sexual harassment or ill treatment of a women employee is found. So these are the primary duties of the employer: to provide safe working environment. He or she should take the necessary steps so that none of the employees should indulge in the sexual harassment case. And if it's so, then the necessary action should be taken to prevent these kinds of act. Moving further, the guidelines also mention that it is obligatory for the employer to file a complaint if the conduct towards an employee amounts to criminal offense which is punishable under the Indian Penal Code. Sometimes what happens, if the woman has faced sexual harassment case, then she is not willing to reveal her identity. Then in that case, what should be done? No complaint should be filed. No, this is not the solution. So in that case, the employer should file the complaint on behalf of that employee, that women employee, and it is the primary duty of the employer. Another thing, if the conduct towards an employee amounts to criminal offense, which is punishable under the IPC. So the employee has faced any criminal offense. Okay, so we know that the criminal offenses are dealt under IPC. So it is punishable under that code, either with fine or with imprisonment or both. It is mandatory for all organizations to set up a complaint redressal committee in order to ensure that the complaint of the employees are dealt properly and suitable action is taken. So this committee should be set up in all the organization for the smooth functioning of the organization, and if any case is found, then that should be dealt properly and suitable action is taken. It is the duty of the employer that when the employee is sexually harassed by a third party, then the employer should assist the employee and he should not deny his responsibilities. The guidelines provided in the case is that the employers are required to assist the employees in terms of both preventive actions and provide support to the victims. Also, it is the duty of the employer to spread awareness in the organization with regards to the matters pertaining to sexual harassment and the safety of women. This can be done by conducting workshops and by other interactive ways to make the female employees aware of their rights. Lastly, it is the duty of the both central and the state government to pass the necessary legislation so that the private sector is also bound by these guidelines. This would help in the growth and prosperity of the women and the nation as a whole. Hope you all have understood the topic in brief, and that's it from my side. Thank you so much.